And here we are. This is the closet docket here where I'm tracking all of the lawsuits against this administration. We have a new one to add today, and I thought I would just read you a couple paragraphs. This lawsuit filed on the 9th of July, just a few days ago, although it seems like eternity. United States of America versus the State of California, number C25-6230. And this is a complaint for declaratory and injunctive relief, the federal government filing against California. Let's take a look and see what's going on. Introduction. The United States is facing a historic cost of living crisis. Overly burdensome and unnecessary regulations have diminished the purchasing power and prosperity of the American worker. As a result, President Trump declared that it shall be the policy of the United States to eliminate the, quote, crushing regulatory burden, end quote, that has, quote, made necessary goods and services scarce, end quote. This is a memorandum by the president on January 20th. So I think what they're saying is that it's California's fault that the eggs are so expensive. That's what I'm picking up here. They've set out multiple counts here, and let's just take a look and see what the premise is, the basic premise for the lawsuit. Count 1 on page 12 of the complaint, paragraph 54. The Supremacy Clause of the United States Constitution provides that, quote, this Constitution and the laws of the United States, which shall be made in pursuance thereof, shall be the supreme law of the land. Anything in the Constitution or laws of any state to the contrary notwithstanding. And they're citing the 6th article to the U.S. Constitution, the Supremacy Clause. So I think they're trying to say here, quote, number 55, under the Supremacy Clause, federal law expressly preempts state law, whereas here Congress, acting within its constitutional authority, expresses an intent to preempt state law through explicit statutory language. I would remind everyone of a case that was ruled on not that long ago by the U.S. Supreme Court, National Pork Producers versus Ross. And this was a California case involving pork production. And the U.S. Supreme Court said you can regulate how you want stuff within your own state. Therefore, the United States respectfully requests that this court, 1, enter a judgment declaring that Section 25990 B3-4 of the California Health and Safety Code and 3 California Code Regs 1320.1 are expressly preempted by the EPIA and violate the Supremacy Clause and are invalid. So they're asking the court to say the California Health and Safety Code is violating the Constitution. So a couple of things to think about. Number 1, is this a retaliatory lawsuit? I think that's fair to ask. Number 2, where is the line between state and federal laws regarding eggs? And number 3, let's just take a look at the people who filed this lawsuit. All right, we have Brett Shumate, Assistant Attorney General, paid for by your taxes. Yakov Roth, Principal Deputy Assistant Attorney General, salary also paid by your taxes. Eric Hamilton, Deputy Assistant Attorney General. Alexander Haas, Director, Federal Programs Branch. Jacqueline Coleman Sneed, Assistant Director, Federal Programs Branch. John Bailey, Counsel for the U.S. Department of Justice Civil Division. So the Department of Justice that you pay for is bringing this lawsuit. And then Bralal A. S.A. Lee, United States Attorney. David Harris, Assistant United States Attorney, Chief Civil Division. Daniel Beck, Assistant United States Attorney, Chief Complex and Defensive Litigation Service. And Joseph Tercey, Assistant United States Attorney, attorneys for the plaintiffs, United States of America. Those attorneys in the Department of Justice, they're working really hard over there with the people that they have left.